This is an appeal in the matter of AXA Fund and another and Santander Cards and another.
Yes, Mr. Howard.
Yes. No, please, Your Lordship, my lady, I appear together with Mr. Zillick, Mr. Scott and Mr. Taylor for Santander, the appellants. My learned friends, Mr. Green and Mr. Campbell, appear for the respondents.
Yes.
AXA. As you know, from around the mid-1970s, AXA, through its predecessors, which I will refer to as Fickle Fackle, provided PPI insurance to consumers in connection with credit provided to them by various retailers, usually at the point of sale. And GECB, Santander's predecessors, had acted as agents for Fickle Fackle, selling on their behalf such PPI insurance to customers.
We know what the case is about.
Yes, well,
We've read the very extensive written material. We don't need you to go through all that again.
no,
And we have read the judge's judgment, so we know what the issues are.
yeah, my lord, of course.
We know the factual background, and we know the competing
Yes, my lord. At trial, as your lordships know, AXA claimed that there was a settlement agreement pursuant to which it could seek an indemnity. That was rejected by the judge and is no longer live. So it had two effectively live claims. One was the claim pursuant to an indemnity pursuant to clause 12.2 of the agreement dated 1st of December 2000, and the other is a claim for contribution under the Contribution Act. And the appeal concerns the judge's acceptance of the claim under the Contribution Act, and the cross appeal under the indemnity, and the cross appeal concerns the contribution.
Yes.
Now, going back just to set matters in context, it's not in dispute that for 20 to 25 years prior to the 1st of December 2000, the parties operated without any formal agency agreement. In other words, they operated under earlier informal agreements or arrangements, and I'll refer to that as the earlier arrangements. Now, whilst GECB might have had liability for breach of duty if the way in which they sold the policies had given rise to liability, they hadn't agreed, it's common ground, any indemnity during that period of the type, or any indemnity, as in clause 12.2. So as you know, the 1st of December 2000 agreement introduced clause 12.2, under which GECB agreed to indemnify Fickle Fackle, and I quote, against any liability which they may incur by reason of any act or omission by GECB, including negligence while performing their duties under the agreement. Now, we respectfully say that that clause is clear and unambiguous. The right to indemnity was dependent upon Fickle Fackle showing an act or omission by GECB, firstly. Secondly, while performing their duties under the agreement. And thirdly, that Fickle Fackle had, as a result of such act or omission, incurred a liability. So the dispute in respect of the indemnity in the agency agreement is whether, despite the wording of clause 12.2, or in the light of the wording, the indemnity applies to acts or omissions, that is to say, selling of PPI in the 20 to 25 years prior to entering into the agency agreement, and indeed while performing their duties under the earlier arrangements. The judge found it did, but we submit she was clearly wrong to do so. Now, if the indemnity agreement did apply to liabilities arising out of acts or omissions that predated the entering into of the agency agreement and while performing duties under the earlier arrangements, it was retrospective. It then would have required an indemnity in respect of acts or omissions which, when carried out, were subject to tortious and contractual duties of care, but which were not subject to contractual obligations to indemnify. Now, you will have seen that the respondents take great umbrage at the reference to retrospectivity and appear to dispute that they are saying that the agreement, that the indemnity is retrospective. Now, we would respectfully say one can understand why they do not like referring to retrospectivity. It is obviously inherently unlikely that a party would agree to provide an indemnity in respect of past conduct, particularly over a period of nearly a quarter of a century, absent very clear words. Now, at paragraph 2 of my learned friend's skeleton, they say there's no suggestion that the indemnity would apply to losses incurred by fickle fackle before the date of the agreement, and that it applies to future losses incurred after its date. Now, there are a number of problems with that. First, the indemnity is not concerned with losses, it's concerned with liabilities. Second, it is concerned with liabilities incurred by reason of an act or omission of GECB while performing their duties under the agreement. So it asks a straightforward question, not when was the liability established, but was it incurred by reason of an act or omission while performing duties under the agreement? Now, there is an undeniable tension in AXA's argument. They appear to argue that the indemnity does not apply to losses, or one assumes liabilities, which arose prior to the agreement. Now, firstly, one might legitimately say if their argument is correct, why not? But secondly, what is interesting to note is the recognition that it is unlikely that parties would agree to an indemnity in respect of past losses or liabilities. Now, that is correct insofar as it goes, but the same logic and reasoning would lead to the conclusion that the parties would not agree to an indemnity against liabilities incurred by reason of acts or omissions at a date preceding the agreement, and indeed where the acts or omissions were not while performing duties under the agreement, but while performing duties under an earlier arrangement. Now, whilst debates about taxonomy are not necessarily productive, it is, we would suggest, difficult to dispute the retrospective nature of the suggestion that an indemnity provision in an agreement entered into on the 1st of December 2000 applies to liabilities referable to acts or omissions while performing duties under an earlier arrangement and going back as long ago as 25 years before. The judge, however, accepted AXA's argument and concluded, in effect, that clause 12.2 does have retrospective application. What she said at paragraph 260 was that the objective intention of the parties was that the entire agency agreement, including clause 12, should apply without distinction to all policies sold by GECB on behalf of fickle fackle, irrespective of the date of sale. Now, we respectfully submit that there were 4 particular errors that the learned judge made. First, she misconstrued clauses 1.1 and 1.2 of the agency agreement, which were the foundation for her view. As to these, clause 1.1 merely recorded that GECB had previously acted as agent and that the parties now wish to record the terms on which GECB should continue to do so. A provision which we would suggest was prospective in nature, but certainly nothing retrospective in it. Clause 1.2, which was perhaps the linchpin of her approach, was not making the agency agreement retrospective. Properly understood, it was a clause designed to make clear what fell within the scope of the agency, the subject of the agency agreement. That is to say, it was describing what it was that GECB was being authorised thenceforth to do. There was nothing in it about retrospectivity. Clauses 1.2, 1.1 and 1.2 also needed to be seen in the context of the agreement as a whole. When viewed in the context of clauses 3, 4, 5, 6, 7, 8, 9, 12 and 17, it is clear that the agreement did not have and was not intended to have retrospective effect. There is nothing in any of those clauses to indicate that the parties intended the agreement to have retrospective effect. Indeed, they are entirely inconsistent with it. Second, the judge's construction was irreconcilable with the clear and unambiguous terms of clause 12.2. The indemnity is against, as we've seen, any liability which Vic or Fackle may incur by reason of any act or omission by GECB while performing their duties under the agreement. That language is plainly prospective in nature. Its focus is on acts or omissions to be done, of GECB to be done while performing the agency agreement, that's to say in respect of duties performed under it. It is notable that, and regrettable, that the judge failed even to consider these words and the associated wording of clause 12 as a whole, which is equally important. Clause 12, and you'll see there are other provisions about indemnity, is entirely prospective in nature, looking at parties' conduct post the 1st of December 2000. So, as I've already said, the issue in relation to the claim for an indemnity is or should be straightforward. Was the liability incurred by reason of acts or omissions while performing duties under the agency agreement? Clause 1.2 didn't provide for retrospectivity, but in any event said nothing to override the clear terms of clause 12.2 or to give clause 12.2 retrospective effect. Indeed,
yes,
as you know,
you've made that point.
yeah. Clause 1.2 was expressly, quotes, unless otherwise stated. And so one had to consider what it was that clause 12.2 stated. The third point where the judge went wrong in our submission was that she drew forced support for her construction for her own conclusion that the aim of the agreement was continuity rather than to bring about any bright line change. That conclusion was at odds with the fact that the indemnity was on any view a new provision and provided no support in any event for not applying the clear language of the clause. And a related point was the judge considered that there would be an asymmetry of commercial benefits and burdens if clause 12.2 was not given retrospective effect. That contravened well-established principles pursuant to which the court's duty is to give clear and unambiguous terms of a written contract effect and not to invoke its perception of commercial common sense or to rewrite the agreement, and ignored the fact that the asymmetry was the result of the fact that the pre-agency agreement contained no indemnity, and ignored the fact that there were perfectly sensible commercial reasons for the parties to decide that they were not disturbing the historical arrangements that existed between them over the previous 25 years, but were agreeing a new regimen going forward. Now, so those are my introductory remarks. Obviously, turning to the question of the proper approach.
Right, asymmetry is the fourth point, is it?
It is.
Right.
Now, it's obviously not necessary before this court to make any submissions about the proper approach to construction.
I think you can assume that we're relatively familiar.
I more than assume it, I know it. But the only point I would make is, the principles get repeatedly stated, and we all know what they are. Lord Burroughs recently summarised them, as you know, in the Providence Building Society case. We've put that in the bundle, but just because it contains a useful summary. But the point I do particularly say is important, and it's the same point that was made in the Palladium Partners and Argentina case, which I think the launcher is present, which is, it's a point that's been made repeatedly in cases, that the court's task is to construe the language of the agreement and not to substitute its view as to what would be a good commercial bargain or anything of the sort. It's for the parties to decide on the bargain, not for the court.
Yes.
Now, so what I'm going to do is I'm going to now go through the respective terms of the agreement. I know your lordship has seen them, but I just want to show you what we say, and it also how it fits together. We accept, I want to make it clear, we don't just say, look at 12.2, we say, as you have to in any of these cases, look at the agreement as a whole. So we're going to do that, but obviously in order to do that, you have to start somewhere. But I'm going to just go through it actually sequentially, and we'll start at clause 1 and work my way through. So that's going to be the bulk of my submission. I will then say something about the aim and commerciality, my overarching submission is none of that is actually relevant in this case because you've got to apply the clear words of the agreement. But even if you are looking at those, there's nothing in them that is inconsistent with what we say is the true construction. So, my lords and lady, turning to the words of the agreement. So, having said I was going to go from clause 1, I'm going to actually go to clause 3 simply because that defines effective date. So clause 3, I assume everybody, you all have it.
Supplemental bundle, page 2.
That's right. So clause 3 is on page 4, and that contains the definition of effective date. The agreement shall commence on the date thereof and continue in force until terminated. If we go back to clause 1.1, GECB has, prior to the date of this agreement, acted as the insurer's agent in respect to the marketing and sale of the insurance. Now, just stopping there for a moment, insurance is a defined term, and you'll see that is on page 3 of the bundle under 2.2d, and that is it's important to in order to understand how this all works, to see that that is a generic description. So you see it's the insurer's creditor and personal accident products and services from time to time. Now, going back to 1.1, so the first sentence is recording that they have acted prior to the date of the agreement, as is the case, as the agent in respect of marketing and sale. The parties now wish to record the terms and conditions on which GECB shall continue to act. So what are the parties doing in this sentence? They are legislating for the future terms on which you shall continue to act. In other words, they're legislating for the terms on which GECB shall continue to act as Fackle's agent in respect of the marketing and sale of insurance. Now, naturally, when parties enter into an agreement, the natural position is they're intending to legislate for future relations, and it's not in dispute, of course, that the agency agreement did at least do that it legislated for their future relationship in two respects, both in respect of marketing and selling of insurance and in respect of the administration of contracts of insurance. Now, as I've already said, it's of course always possible to enter into an agreement and to provide that it legislates for your past relationship as well as your future one. But we would suggest that where that is intended to be done, you would expect it to be made clear, and also to make clear in what respects any retrospectivity applied. Now, for instance, if the agency agreement was intended to be retrospective and to apply to the party's past relationship, you would expect that it would have said something to the effect that, looking at the second sentence of clause 1.1, having noted that they have, prior to the date, acted as the insurer's agent, you would expect it to say that the parties now wish to record the terms and conditions on which GECB shall be treated as having acted previously and shall continue to act. So, whereas what it just says is shall continue to act. You'd also expect that all the other terms were consistent with retrospective application. Now, in our submission, you don't find any provision here which is making this retrospective and to be treated as if it were always in force, nor is the remainder of the agreement consistent with retrospective application. Now, before considering 1.2, which it is AXA's case and the judge is finding that is the clause which is to the effect the agreement does apply to pre-2000 sales. Before we look at that, it's important to bear in mind the way in which the contract works and the different concepts being used. I've already shown you the definition of insurance. Now, insurance is described generically to cover creditor and personal accident insurance products and services. But the way in which, and we'll see this more fully in a moment, the authority under which GECB operated was to sell insurance under the schemes. The schemes are in fact what delineate the authority. And there were numerous schemes. There were over 150 of them. I think there are 156. They are set out in Schedule 4 to the agency agreement, which is at addenda pages 1 to 35 or pages 27 to 102. And you'll see sometimes there are a whole list of these different policies, of what are called policies, but they are the scheme. Now, you then have separate to that the contracts of insurance or policies that are entered into with the customer. So a customer gets sold under the scheme a contract of insurance. It's perfectly standard. I mean, we're all familiar with it with, say, travel insurance, where there's a master policy of some sort that an agent has. Now, the definition of schemes, you'll see on page 3 of the manual at the bottom, at 2.2f. So it means the existing schemes for the marketing and sale of the insurance set out in Schedule 4, so it's those already in existence, and any new scheme launched by the parties for the marketing and sale of the insurance after the date of this agreement, the details of which are set out in an addenda executed by the parties. So there were in existence at the date of the agreement, firstly, a number of existing schemes, over 150, under which GECB had been marketing and selling PPI products on behalf of Fackle Fickle. And they've been doing that since the particular scheme's launch date. You'll see, if you care to look at it, I won't take you to it, in the addenda. Sometimes there is a launch date specified. For a very large number, it just says various dates. And it's common ground that in some cases it goes back, maybe it was quite sure, but to sometime in the 1970s.
Yes.
Sorry, before.
It may not matter, but
Yes,
just catching up with you, on page 4 there's a reference to clause 4.4 for new. That seems to be a typographical error.
Yes,
It's
that might,
4.3, I guess.
your lordship is entirely right. Sorry, I should.
Sorry to interrupt.
No, not at all. I should have pointed out it was that error. So the idea was that GECB would continue to market and sell insurance both under the existing schemes and under new schemes if they were added to Schedule 4. Now, the other point to note is, and again, if you see the definitions, in 2.2c and e are definitions respectively of existing on-risk policy and new policy. So, so these are things that either have been sold or are going to be sold under the schemes. Existing on-risk is a creditor insurance policy, etc., entered into before the date of the agreement between a customer and the insurers, pursuant to one of the schemes set out in Schedule 4, under which an insured customer has made a valid claim which remains outstanding, or there remains a risk the insured may make a claim in accordance with the terms of the policy, whereas a new policy is a creditor insurance that entered into in or after the date of the agreement between the customer and the insurers. Now, turning back to clause 1.2 on the prior page, you can see that firstly it operates as the first clause says unless otherwise stated. Come back to that, it's obviously important as clause 1.2 is in any event subject to what other provisions say. Now the provision goes on to say in the next part that it is notwithstanding clause 3. And we've seen that clause 3 provided that the agreement would commence on the effective date, which was the 1st of December 2000. Now in our submission there were 2 points that the parties were seeking to address in clause 1.2. The first was to make it clear that although the various schemes had then in Schedule 4 had been in existence prior to the date of the agreement and the terms on which GECB shall continue to act would thenceforth apply to the marketing and selling of insurance under such schemes as well as under new schemes. And in our submission, that is what the first part of the clause is addressing. It is defining the scope of the authority being granted under the agency agreement in relation to sales and marketing, such authority being granted by this agreement by FACL to GECB. So that is what the first part of the clause is concerned with up until the comma. The second part of the clause, which begins with the ongoing administration of all existing on-risk policies and new policies, that is concerned with administration. Now, what the parties were concerned to ensure was that the agreement, the agency agreement, applied to ongoing administration of existing policies as well as the administration of new policies. Now, the thing to note about that, of course, is existing policies would already have been, at least partially, or would already have been subject to administration. The purpose of the clause was to make clear that ongoing administration, that is to say, after the 1st of December 2000, was subject to the agreement, whether such administration was taking place in relation to an existing policy or a new one. Now, the effect of that was that the agreement did not cover and was not intended to cover prior administration that had taken place at an earlier stage. Such administration was just covered by the general law. In other words, in relation to administration, there was no question of the agreement applying to anything other than from the 1st of December 2000. Now, by way of general observation, we suggest it would be strange indeed, and there would be no sense in providing that the agreement and its terms applied to marketing and sales prior to its date, but not to administration prior to its date. And we say they did not. Because the provisions of clause 1.2, we suggest, are plainly concerned with, firstly, prospective marketing and sales under any of the schemes, secondly, prospective administration of all policies, existing and new ones, and thirdly, rights and obligations from those matters. The reason the clause says, notwithstanding clause 3, is, as I've said, to make clear that although the agreement commenced on the 1st of December 2000, it applied to the prospective marketing and sales of insurances under schemes and the prospective administration of policies, notwithstanding that the schemes and policies might have been enforced prior to that date. Now, you will see, if we go back to the words in the first part of the clause, it uses the expression, this agreement shall apply to and govern the marketing and sale of the insurance under all of the schemes, including the schemes set out in Schedule 4, in respect of which there are in existence at the date of this agreement existing on-risk policies. Now, the words in parentheses were intended to describe all schemes under which policies had been sold. Now, schemes, as you've seen, is, if I just remind you, sometimes people keep this in mind, if one goes back to page 3, is defined to include the existing schemes set out in Schedule 4 and any new scheme added to Schedule 4. The words in parentheses are intended to make it clear that all schemes which had been set up are included, including those used previously and in respect of which risks had already attached. In other words, the fact that risks had been attached under a scheme did not prevent those schemes going forward, falling under the authority being granted to GECB. In other words, it's saying for the future, the authority we're giving you is granted by this agreement and not the earlier arrangement. But this was not concerned, we suggest, with applying the agreement retrospectively to sales under the earlier arrangements. Now, a suggestion has been made in a number of places in AXA's argument that if this agreement only only related to prospective marketing and sales, as we say, the parties would have used the expression new policies, which is defined in clause 2.2e, or at least new policy is defined there, rather than insurance under all of the schemes. That is confusing two things. It is confusing the definition of the authority being granted with the outcome of the exercise of the authority. Now you can see that from the following. If you go to clause 4, clause 4.1 records GECB's appointment, or confirms the appointment as the non-exclusive agent to market and sell the insurance. What it doesn't do is tell you what insurance products fell within the scope of their authority. Where do you find that? What is telling you what is within the scope of the authority? That is simple. The purpose of clause 1.2 was to describe the scope of the authority then being granted.
Don't you get that from the definition of insurance?
No, because, well, you would, but that would be, as I said, it's quite important to note, insurance is all in rather generic terms. So insurance means the insurer's creditor and personal accident products and services from time to time. Now, AXA could have all sorts of personal accident policies which actually weren't intended to fall within this. For instance, a personal accident policy to do with your everyday activities or something like that. Whereas now, if it had just stood there, that would be general. But the way the agreement operates and the way the parties' relationship operated, they only actually had authority to sell insurance products that fell within each of the schemes set out in Schedule 4. And you only get that from clause 1.2. That's where the scope of the authority, delineating it by reference to clause to Schedule 4 and the schemes, comes from 1.2. So, in other words, GECB were not in fact being authorised to continue to act in respect of any of the insurers, creditor and personal accident products. They were being authorised to continue to act in respect of marketing and sale, to confine ourselves to that, of insurance under the schemes. And as we've seen, the schemes, when you go to 1.2, are, and the definition of schemes, are both existing ones and new ones. Now, it would have been wholly inapt to refer in 1.2 to new policies, in other words, to substitute for insurance under all of the schemes, to substitute for those words new policies, because new policies, or if you go to the definition, back to the definition of new policy, that is a creditor insurance or personal accident policy entered into on or after the date of the agreement between an insurer customer and the insurers pursuant to a scheme. In other words, it is describing what's being done under the authority and not what is within the authority. So clause 1.2 defines the scope of the authority being granted, that is to say, to market and sell insurance under any of the schemes. And in our submission, this was plainly prospective in nature. There was nothing about retrospectivity, and there's nothing in the use of the term insurance to denote the parties intended the agreement to apply retrospectively. Now, paragraph 281 of the judgment, the judge referred to an argument that was made below by Santander. In the first sentence, she says that Santander's final point was that if AXA's construction were correct, it made no sense to limit the agency agreement to existing schemes while ignoring schemes which had been discontinued. The thrust of the argument was that existing schemes did not encompass ones which had been discontinued. The judge rejected that, as appears in the following passage, referring to evidence from Santander. So she said, Mrs. Greenway's evidence confirmed that the only schemes which were regarded as discontinued for the purposes of the agency agreement were those under which no policies had ever been sold. Schemes under which policies had been sold which could still be reactivated or give rise to claims, and by give rise to claims I think she must mean the insurance policies under them could give rise to claims, despite being dormant for years, were not treated as discontinued but regarded as existing schemes. Thus, Appendix 4 to the agreement included several schemes under which no premium had been collected since '95 and under which no policies could have been sold after the effective date. This also provides some support for the view that the agency agreement must have been intended to apply to historic marketing and sale under those schemes. You see, the judge suggests that her conclusion in this paragraph provides some support for the view the agency agreement must have been intended to apply to historic marketing and sales. Now, we suggest that's not a good point for the following reasons. First, as I've said, the reference to claims is must be to claims under insurance policies. But the essential point she was making is that the only schemes that were treated as discontinued for the purpose of the agency agreement were those under which no policies were ever sold.
She puts discontinued in quotation marks, but it isn't a quotation of anything in the agreement, is
No,
it?
I don't know why she did that. I don't know what she's referring to, or just. I mean, I suppose she may be saying the way that people do colloquially say discontinue.
Or it may be to the Mrs. Greenway's evidence.
Yeah,
I think that's right.
Yeah, it may be, but I don't think anything stands on it. Now, one, if not the preeminent purpose of the definition of existing policies was to define GCB's obligations in respect of administration. GCB was responsible for the ongoing administration of such existing policies, including claims thereunder. Now, as I've explained in our submission, the first part of clause 1.2 was intended to define the scope of the authority being granted under the agreement in relation to marketing and sales. The definition, the parties chose to define that by reference to all schemes and made it clear that that even included ones, or did include ones, under which in the past policies had been issued. The fact that some schemes were effectively dormant didn't change that. Indeed, the judge herself notes in that paragraph I showed you that dormant schemes might be reactivated. And even if there were some schemes which could not be reactivated, as she appears to be saying, that does not inform you of anything. The words in parentheses were including. That in our submission is to make clear that the authority, for the avoidance of doubt, did include any schemes where policies had been sold under them and risks had incepted, and that might otherwise have been in doubt. The fact that the definition might have included schemes which for practical purposes were dormant doesn't tell you, we would submit, anything about retrospectivity. The purpose of the words was not to make this a retrospective agreement. Now, a similar and related point, if we go back to clause 1.2, relates to the use of the term ongoing in the second part of the clause before administration. Now, ongoing is used in relation to administration because it is intended to make clear that the agreement applies to the continued administration of insurance contracts were never entered into, but only in respect of administration after the 1st of December 2000. What the parties wanted to make clear was that whilst a particular policy might have been in existence and administered prior to the agreement nevertheless applied to the administration after its effective date. Now, if ongoing had not been used before administration, there would be a potential issue where a policy was partially administered before the 1st of December 2000 and partially after. There would then be an agreement as to how the agreement applied, and ongoing in our submission provided the answer, namely that all administration, whether it's of an existing policy or a new policy, after the 1st of December is subject to the agreement. And in our submissions, as I said, it would be odd to agree that administration pre the 1st of December 2000 was not within the agreement, but sales were. So there was, on the other hand, no need to use ongoing. And my friends say, why isn't ongoing before the marketing and sale? There was no need to, as marketing and sale was not concerned with anything other than future activity. That is to say, marketing and sales of the products for which GECB was being given authority by the agency agreement to continue to act. So, in our submission, the provisions of in clause 1.1 and 1.2, properly construed, are clear, coherent, and rational. Firstly, the agreement applied to future marketing and sales in administration. Secondly, within that, it applies to such future marketing and sales pursuant to or under schemes which already exist as well as new ones. And thirdly, it applies to future administration of policies insurance, including those already in existence as well as new ones. Now, my lord and my lady, clause 1.2, as I foreshadowed, needs to be seen in the context of the other provisions of the agreement. And we submit, when you look at the other provisions, they are all prospective and forward-looking, and not a single one is retrospective or concerned with anything that happened during the prior history of the parties' relationship. So we can take these quite quickly. Clause 3 you have seen, but that is saying clearly that the parties' rights and obligations under the agreement commence on the 1st of December 2000. Clause 4.1 confirm the appointment, the insurers hereby confirm the appointment of GECB as their non-exclusive agent to market and sell the insurance. There's nothing in that to indicate retrospectivity. What clause 4.1 is doing is mirroring what is in clause 1.1, which we looked at, that the parties now wish to record the terms and conditions on which GECB shall continue to act. Now, as I've already submitted to you, it's also clear that 4.1 does not itself fully define the scope of the authority. In other words, it doesn't define which schemes GECB are entitled to market and sell, and which insurance policies they are required to administer. The answer to that is supplied by clause 1.2. And as I've said, the words notwithstanding clause 3 appear in 1.2 to indicate that despite the agreement commencing on the 1st of December, the scope of the authority is defined by schemes that were already in existence, and there were obligations to administer policies already in existence. Next clause 5 on page 4. See, this agreement is subject to the ABI Code of Practice for the selling of general insurance. The ABI Code, each of the parties shall comply with the terms and conditions of the ABI Code for as long as the same remains in existence. Now, the first thing to note, the second sentence, shall comply, that is plainly forward-looking language. That is what the parties shall do in the future. So not on its face concerned with the past. Moreover, if the agreement applied retrospectively, it raises at least difficulties or issues. Let me explain. The ABI code to which reference is being made was in fact introduced in 1989. Now, it was in materially similar terms to an earlier code introduced by the BIA, a forerunner of the ABI, but which was introduced in 1981. That's set out in the judgment at paragraph 62 to 3. So bearing in mind that what is being said, you've got retrospectivity back to the mid-1970s, you have a period where there's no code, then you have a period where there was a different code, BIA code, albeit in materially the same terms. Then from 1989, you have the ABI code. Now, if it truly was the case that these parties intended it to apply to sales and marketing from the mid-1970s, we would suggest it is curious that the standard of conduct of the parties is expressly defined by reference and subject to a code that did not exist until 1989, and where even the earlier equivalent code of the BIA didn't exist until 1981. While there may be arguments that these codes just reflect standard conduct, it is still odd if the agreement was to be retrospective to define conduct over the previous 25 years by reference to codes which didn't exist when some of the selling took place. And of course, these issues don't arise if the agreement is forward-looking, as we say it is. Clause 6. This is setting out in two parts GECB's duties. 6.1 deals with what GECB will do. 6.2 deals with what GECB will not do. All of that, when you look at the terms, is forward-looking. For instance, each one is, but I mean, just taking a random example, 6.1F, ensure that all personnel involved in the marketing and selling of the insurance are trained to the insurer's reasonable satisfaction. Now, in our submission, an agreement drafted in these terms sits ill with the idea that it is meant to be retrospective. So clause 7, the insurer's duties. Now, this is an interesting one. This defines 7.1, and this is important when we come to 12. 7.1 defines what the insurers will do during the term of this agreement. Now, that could not be clearer. It's actually impossible to argue that is doing anything other than imposing duties from the 1st of December, because that is the term of this agreement. 7.2, the reason they use those words, you might wonder, why is that there in 7.1? We don't find equivalent words in 6.1 and 6.2. That's because the parties for the insurers distinguish two situations. One is during the term, and 7.2 is during the run-off period. And the run-off, I think, is defined at 14.4. It commences on termination of the agreement, when the parties agree that everything's expired. So it's clear, I would suggest, beyond any doubt, that Fickle Fackle only have, under the agreement, duties from the 1st of December 2000. Clauses 8 and 9, they are matters which are dealing with premiums, initial and commission and profit share. They are all prospective. Now, you might say, well, there's nothing particularly surprising about that, because this agreement was concerned with ongoing administration, as I've already submitted. But the important point for my lord and my ladies to note is that there is no distinction between the way these clauses are structured and what they're saying, and the provisions of that we've already looked at in 5, 6, and 7. Now that then takes one to clause 12, the key clause. And forgive me if I just spend a moment just asking you to reread it, because it is important. You see in 12.1, subject to GECB complying with their duties under this agreement, the insurers will indemnify GECB against any liability which they may incur by reason only of being held out as insurers' agents. So that's an indemnity that applies to GECB, and you can see what it's getting at. If, as a result of their selling the insurance and they're held out as the agents, if they incur a liability just because of that, then they're entitled to an indemnity. Then 12.2, and this of course will remind you of clause 7, subject to the insurer complying with their duties under this agreement. So that's the first part of the clause. The insurer must comply with their duties under this agreement. Then the second part, GECB will indemnify the insurer against any liability which they may incur by reason of any act or omission by GECB while performing their duties under this agreement. Now, so the first thing to note in 12.2 is that Fickle-Fackle's right to indemnity is dependent upon their complying with their duties under this agreement. So this mirrors their position, mirrors the indemnity provision, which is in respect of any liability which Fickle-Fackle may incur by reason of acts or omissions by GECB while performing their duties under the agreement. So one of the things in our submission that is necessary is to consider how the two parts of the clause fit together. Now, taking the second part of the clause, we've already seen that, or you already have my submission, that where the insurer has incurred a liability, it's necessary to show it did so by reason of an act or omission of GECB, etc., while performing their duties under the agreement. Now, in our submission, since the agreement only came into force on the 1st of December 2000, and since the duties prescribed by, for instance, clause 6 are all prospective in nature, GECB will, or GECB will not, we suggest it's extremely difficult to see how an act or omission in relation to selling a policy in 1982 or 1992 or any date before the 1st of December 2000, or indeed administering a policy, a contract of insurance on such dates, can be while performing their duties under this agreement. Now, as I've said, a second important point on clause 2 arises out of the first part of the clause. The entitlement of the insurer to an indemnity is dependent on the insurer complying with their duties under the agreement. Now, there was an argument at the trial about how strictly they would have to comply with their duties. Now, that's not relevant for present purposes. For present purposes, it's sufficient to note that the clause does provide a condition precedent to the entitlement to an indemnity. That's to say, the insurers complying with their duties under the agreement. But that then leads to the question, well, what are their duties under the agreement? And as I've shown you, it's clear that the insurer's duties are only during the term of the agreement or during the run-off, because that's what clause 7 says. Now, there was obviously intended to be a symmetry between the two provisions in the clause. Provided Fickle-Fackle perform their duties under the agreement, they get an indemnity for what GECB do while performing their duties under the agreement. Each is the mirror image of the other. The right to the indemnity for what GECB does is dependent on Fickle-Fackle complying with their duties under the agreement. And in our submission, when you see that, it's plain that everything is looking at the matter prospectively from the 1st of December 2000. And the scheme does not work if one says there is an indemnity for sales pre the 1st of December 2000, while GCB were performing their duties under the earlier arrangements. Because during that period, it's plain that the insurers had no duties under the agreement. That's plain from the terms of clause 7. And it would be very odd indeed, we would suggest, if the insurers have no obligations prior to the 1st of December 2000, but somehow GCB is liable, and there's nothing for the first part of the clause to bite on, and yet they're entitled to an indemnity, and GCB has agreed to that.
Does the judge identify which duties have given rise to the indemnity that she found?
Well, the way, of course, it works, because it's any act or omission, it's simply the act of selling. If the selling, so as you know, in terms of PPI sales, the problem with PPI is, in summary, it sort of has two components. One is that it's either a product which is unsuited to the majority of consumers, or it's unsuited without an adequate explanation.
Yeah.
And so the error or omission is selling without giving proper explanations so that people understood the limited circumstances in which they might be able to call them. And essentially, it wasn't a product that was good value for money. But so in the context, the regulatory liability that they've incurred, which they've been told by FOSS that they are liable to make redress, is essentially, of course, selling these products either at all or without adequate explanation. Yeah. But you can consider this by, I mean, maybe this is just an obvious illustration, but I'll make it in any event. Assume there is conduct after the 1st of December 2000 by Fickle Fackle, which means they are in breach and they cannot bring themselves within the first part of the clause. In that situation, they have no right to an indemnity. And sorry, was your lordship asking me what sort of conduct by Fickle Fackle?
No, I was asking what duties under the agreement did the judge identify so as to bring the indemnity into effect?
Well, you don't have to point to a breach of duty as such. I mean, it's just because it's any act or omission
While performing their duties?
Yes. So the duties are selling.
I see.
It's just selling the insurance. If selling the insurance, because if that's caused a liability, I mean, it's got to be something that relates to your act or omission. So if you have not explained it or you've sold it to somebody to whom it's not suitable. But as I was pointing out, if Fickle Fackle are in breach of their duties in a way that would matter after the 1st of December 2000, then they couldn't bring themselves within the indemnity provision. But assuming the identical conduct before the 1st of December, Fickle Fackle's argument is that the indemnity that GCB has provided applies to sales before the 1st of December 2000. But then GCB wouldn't be able to point to any obligations, any duties under the agreement that the insurer had. So you would have a mismatch between the first part of the clause and the second part. In our submission, that shows why their construction cannot be correct. It's also instructive to look at the related provision in clause 12.1. Subject to GCB complying with their duties under this agreement, the insurer will indemnify against any liability it may incur. In our submission, again, this is plainly intended to look at things that you do under this agreement, which commenced on the 1st of December, and that's where you get your indemnity. Now, as you have seen, one of the difficulties with the judgment is that the judge does not at any stage in her judgment actually construe clause 12 and the other clauses I've shown you. She confines her analysis in effect to clauses 1.1 and 1.2. So she says at 279 that if Santander were right, the mis-selling of policies prior to the effective date was excluded from the scope of the agreement. I agree with that, so it would lead to a surprising asymmetry, with the majority of the commercial benefits going to GECB and Fickle Fackle picking up all of the liabilities. even if attributable to GECB's acts and omissions. In my view, and this is the critical sentence I wanted to draw attention to at this stage, much clearer wording would have been required to achieve this effect. I'll come back to the asymmetry point in a moment, but the last sentence is a curious approach. The wording of clause 12.2 is not set out. Now, the first thing is, the correct approach was to consider the language of the clause.
Yeah, I think the only bits you get about that are in paras 275 and first sentence of 276.
Well, my lord, what 275? She refers to my learned friend who's acting for Santander, making a submission to Mr. Zelig.
Yes.
275 is what she refers to as a powerful argument, and then she says, "I'm not persuaded."
Yes.
And that's it.
That's it.
Yeah, and I mean, you know, with all respect, that's just not the right approach. You've got to look at the language, and her ladyship has fallen, I would respectfully say, into the trap of determining what she thinks is the commercial sense, and giving that, as it were, overarching effect, rather than construing the words. And what she's actually done, and that's why I took you to that sentence in 279, she says you'd need much clearer wording. Well, the inclusion of the words while performing their duties under this agreement, particularly when you see it in the context of clause 12.2 as a whole, does offer such clear wording. You have to see the clause as a whole. And the natural meaning of the words, and I would suggest the only coherent one, is that the indemnity only applies to liability arising from sales made while performing duties under the agreement. That is to say, since...
Presumably the much clearer wording
Yeah.
to which she is referring at the end of paragraph 279 is much clearer wording in clause 12.2 would be required.
I don't know. Yeah, I suppose she means that. I suppose she does. But the problem is, if you don't set out the words and analyse what the words mean, it's slightly difficult to, because she's not saying in what respects these words aren't clear. But so that's one point. But the other point is what she's doing is that she's approaching the matters with respect entirely the wrong way round. She hasn't started with the language, and that's why it is important to bear in mind what the authorities say, that the language is what is key in an agreement. And what instead she's got is a predetermined view and still doesn't consider the wording, or we'd say worse, actually ignores it. Now, an interesting observation for the court is this. The respondents below recognised that the wording of clause 12.2 was problematic for their argument. If you go to the supplemental bundle, you'll see how they sought to deal with it in their submissions. At page 287, I think it is. Yes, page 287 is the closing skeleton argument, using the word skeleton advisedly. And at 192.3, they say, they referred to, this is referring to 12.2, duties under the agreement. That language can readily be and should be read as meaning duties to which this agreement applies or duties that are governed by this agreement. So they were right to recognise that their case requires one to rewrite or reinterpret the clause, because while performing their duties under this agreement can only sensibly be a reference to something done on or after the 1st of December 2000, because it's only on or after that date that GECB are performing their duties under the agreement. Now, there's no warrant for changing the wording in this way, and what is more, it doesn't address the point that I made before. We go back to the agreement in 12.2. So the first part of the so they want you to read it instead of the last clause saying while performing their duties under this agreement. They say the effect of their argument is 1.2 makes sales earlier as subject to the agreement, and so a sale at an earlier stage is to be treated as one where you are performing your duties to which this agreement applies, or duties that are governed by this agreement. So you don't rewrite that. But the problem that there's no basis for rewriting this in that way. That's my first point. The second is you'd still be left with subject to the insurer complying with their duties under this agreement. And even if you try and read that as saying with their duties to which this agreement applies, well, this agreement only has duties on the insurers after the 1st of December 2000. That's what it says. And what essentially all of this shows is that you have to our submission is clause 1.2 didn't have retrospective application, but in order to make clause 12 work, you'd have to do a lot of damage to the agreement. So, and in fact, even on their case, you'd be left with a mismatch between the insurer's obligations, which are a conditioned precedent to their entitlement to an indemnity, and that in respect of which they're entitled to an indemnity. Now, AXA make another argument at paragraph 14 of their existing skeleton. They say that the words, while performing their duties under this agreement, are intended to impose what they describe as a subject matter and not a temporal distinction. Now, they say the words were intended to ensure that sales which were made under an arrangement that is not added to the list of schemes is not covered by the indemnity. Now, that's wrong for a number of reasons. Firstly, a subject matter limitation, in other words, telling you what is covered by the agreement in terms of what sales fall within the scope of it, is provided by clause 1.2, because a scheme which is not in Schedule 4 is not part of the agreement. So if you don't add a scheme to Schedule 4, a new scheme is not part of it. Now, clause 12 is plainly a temporal and a scope provision. So the first part of 12.1 and 12.2 is both looking at what it is you're required to do, and also it's got to be under this agreement. The last part, using the words while and under, also make it clear that the indemnity is limited to things done, sales, while performing under the agreement. So that then takes me to the final clause I wanted to look at, which is clause 17, which is the whole agreement clause. So as you know, this provides that the agreement contains the entire and only agreement between the parties relating to the marketing and sale of insurance by GECB from and including the effective date, and supersedes and invalidates all previous agreements and understandings in relation thereto. Now, in our submission, this makes clear is that the agreement is the only agreement for marketing and sales from the 1st of December 2000. It is the entire agreement in respect of things that fall within the scope of the agreement, namely the marketing and sales of policies from the effective date. And that is why the words from and including the effective date are there. And indeed, if the agreement was retrospective so that it applied forever, or from the beginning, from 1975, it's difficult to see why you would need the words from and including the effective date, because the agreement on their case is intended to be the only agreement ever to apply. And what those words are making clear is that from the effect, in relation to marketing and sales from the 1st of December 2000, this is the entire agreement. And in that sense, invalidates previous agreements, but it's not invalidating otherwise the agreements that existed from 1975 to the 1st of December 2000. That continues to apply to what was done during that period. Now, an objection raised by AXA is that this creates distinct and parallel regimes for dealing with future losses arising from the sales of policies depending on the date of sale. Now, first thing to note is, as I've said, it's plain that administration pre the 1st of December 2000 and post the 1st of December 2000 are subject in any event to different regimes. And in our submission, sales and administration are treated the same. Sales and administration under the earlier arrangements would be governed by and covered by the general law. Sales and administration thereafter are covered by the terms of the agency agreement and including the indemnity provided in 12.2. There's nothing difficult in that, simply reflects, at the end of the day, the regime the parties have chosen. It was up to the parties to choose what to do. It's not for the court to say, well, this might be better than that, or this is a bit inconvenient. These were parties who could decide we're going to have a new regime going forward, which doesn't disturb the previous regime. So just focusing as we have on the wording, before I look at the arguments made on factual matrix, aim, commerciality, whatever you want to call it, just looking at the wording. In our submission, firstly, the wording of clause 12.2 is clear and unambiguous. We submit that the judge misconstrued clauses 1.1 and 1.2, which was foundational to her construction. And in particular, clause 1.2 does not connote retrospectivity. But in any event, she failed to construe clause 12.2. That on its face only applied to, well, I won't make the point again, but you know what I say. And the clause, in any event, provides its own scheme in relation to indemnity. Even if clause 1.2 did otherwise make the agreement retrospective, and we say it didn't, but even if it did, so as to apply to sales under the earlier arrangements, that provision was subject to the unless otherwise stated provision. Clause 12.2 is an unless otherwise stated provision because it makes clear how the indemnity applies and its limits. Now, my lords and my lady, the wording of the agreement we submit is clear, and that should have been the end of the matter. The additional matters which seem to have influenced the judge, particularly under the heading of aim and asymmetry, none of those, we say she hasn't actually got the point right, but none of them is sufficient to displace the agreement that the parties have made. So turning to aim of the agreement, a matter which we say was at best to be factored into an iterative interpretation. The judge characterised the aim as being to effect continuity in the relationship between Fickle Fackel and GCB. Now that is partially, but only partially correct, because while it was there was continuity, It also introduced, as is common ground, at least a new provision concerning indemnity. The judge found, and this was an issue at the trial, there was no express or implied indemnity prior to the agency agreement. So that was an issue being argued. So to that extent, at least, its aim was not simply to affect continuity, but to introduce new rights and obligations. And so the aim was it doesn't really tell you anything when there is a new term. The question is, well, this is a fairly fundamental new term. When and how does it apply? Now, at this point, the judge made a number of further errors. First, she said that the idea of continuity was further supported by clause 4.1. I've taken you to that, and that doesn't do any more than confirm GECB's appointment. She also said that the witness evidence showed that there had been no intention to alter the nature of the relationship. Now, whether that, one can debate whether that material is admissible, but there was, on any view, an intention to change the relationship so far as concerned the position on indemnity. Now, she also says that, which is a similar point to one we've already looked at 272, she said that on the premise the aim of the agreement was to achieve formalisation of arrangements already being operated, she said one would expect it to be clearly stated if it had nevertheless been intended to draw a distinction for any specific purpose between policies sold after the effective date and those sold before. Now that was actually erroneous for a number of reasons. It was actually erroneous on its own terms, because the agreement did in fact draw a distinction between, if you're talking about policies, because it drew a distinction between administration before and after the 1st of December. But in any event, we say the agreement wasn't retrospective for any purpose. And in the further point we've already made, that the agreement, the indemnity in clause 12.2 was limited to when performing duties under the agreement. This is another instance, it's repeated, of the judge looking at things the wrong way round. Similarly, she reasoned at 267 that it was most unlikely intention, viewed objectively, that existing, I think it's the same point. It's really, she says that you shouldn't treat existing policies and new policies differently for the purpose of the indemnity. I say that was inaccurate on its own terms, because the administration was treated differently. But more importantly, perhaps for the current debate, there's nothing inherently unlikely about this. The effect would simply be that the agency agreement applies, as you would expect, prospectively, both to sales and administration, whilst what had happened before continues to be governed by the arrangements that existed before. That's a perfectly sensible view. One can argue, if you were a commercial man negotiating the deal, which one you prefer. And similarly, she says at 272 that there was no logical or commercial reason for why the parties would have intended GECB to be liable for the consequences of its acts or omissions in relation to the new policies, but not existing policies. Now, of course, there's an error in that GECB was, we're not arguing about whether they were liable for their acts or omissions, we're arguing about whether, in addition to their common law and contractual obligations and liabilities, there was an indemnity provision, which is introduced by 12.2. So that's the first error there. The second is she fails to construe, as I've said, the language of 12.2, and she substituting her view of what she regarded as sensible. And as I said, there were ample reasons why commercial people might regard it as sensible to define things going forward. So there was nothing illogical or uncommercial in that. The next point the judge made is that she said Santander's construction would give rise to logistical difficulties where the reporting system didn't distinguish between existing policies and new policies. The difficulty with that is it's difficult to see how it actually bears on the proper construction of the words, but in any event, what the clause is concerned with is GCB's conduct and when a sale is made, or when administration takes place for that matter. It doesn't require a reporting system which distinguishes between existing and new policies. It just requires you to be able to ascertain when the relevant conduct occurred. That doesn't entail any difficulty or any particular difficulty, and certainly not to justify rewriting clause 12.2. The next point under this heading that the judge made at 273 was she referred to the fact that agency agreements between insurers and credit lenders invariably contained an indemnity agreement of this nature. Now, the difficulty with that is, so what? In this sense, the question is not...
Well, she found that this particular relationship didn't contain such.
Exactly. So it really takes you absolutely nowhere to say, where she's using it. Well, this is where, with respect, she's taken her eye off the ball. The question is not, do you expect there to be an indemnity provision? The question is, did this indemnity agreement, did the agreement apply retrospectively, and did the indemnity apply retrospectively? Saying that very often you have, or usually you have, indemnities doesn't tell you anything in my respectful submission. So those are points on aim and factual matrix. Asymmetry, which is really just a related point, where the learned judge said, well, essentially she's saying it'd be a rum thing if GCB get the majority of the commercial benefits and Fickle-Fackle pick up the liabilities. Well, if you actually think about that for a moment, the consequence, if we're right, is that the reason Santander GCB are not liable is that the claims that have been brought against them are out of time. It's not that they didn't ever have any liabilities. What is happening here is that there is a mismatch between the limitation period that would apply to claims for breach of contract and in tort and the indemnity provision. But that doesn't, with respect, tell you anything. It's not, there isn't this asymmetry that she's talking about, because if there was asymmetry, that existed for 25 years when there was no indemnity provision. And so what the judge is trying to do is to rewrite clause 12.2 to avoid what she's saying was an uncommercial allocation of risk and reward, but was the allocation of risk and reward that the parties have been happy with for 25 years. Now that, with respect, this doesn't make any sense at all. And when you talk about this asymmetry, it is actually just, there isn't true asymmetry, it's just that the indemnity operates in a different way to duties at common law, and this was something that was introduced in December 2000. So in our submission, those points don't assist. So with respect, this is a case where the learned judge took her eye off the ball. She failed to recognise that the court's preeminent task was to construe the words of the agreement. She appears to have been unduly influenced by her view of what would be a commercially sensible agreement for the parties to have made. And simply, we say the words of the agreement are clear, they don't have retrospective effect and don't apply to sales and marketing in the previous 25 years. In any event, the indemnity is even clearer and more unequivocal, and the insurers are only entitled to an indemnity that falls within its terms, and sales and marketing, the earlier stage, don't. So, my lords, we ask you to allow the appeal. And I'll just say one word about what is the consequence of that. The matter would be, the parties should be able to agree what the consequence is, so that, which is, as I think you know from our submissions, 85% of the liabilities relate to the position prior to the 1st of December 2000. The parties ought to agree what the precise figure is. That hasn't actually been investigated in the sense of being found. But if the parties couldn't agree it, then it would have to be remitted back to the trial judge just to make that determination. I'd be astonished if between AXA and Santander that were necessary, but that would strictly be the position. So, my lord and my lady, those, I hope I haven't gone too quickly, but those are my submissions. Yeah.
Yes, Mr. Green.
Sorry, can I just grab the lectern from my
Yes, of course.
learned friend? Thanks. What I propose to do is I'm going to start just by summarising very briefly AXA's construction, and then I'm going to move on to a gentle trot through some of the contractual clauses, and then also take the court to certain passages in the judgment which show what the parties were trying to do or were doing when they recorded their relationship on the 1st of December 2000. Now, Santander's central construction argument on appeal is that the concluding words of clause 12.2 are a clear and unambiguous reference to acts or omissions after the agency agreement was entered into, because it's only then that GECB could be performing their duties under it. Now, AXA, by contrast, contends that the meaning of those concluding words of clause 12.2 obviously can't be determined in glorious isolation, and they have got to be construed in the light of the scope setting provision in clause 1.2, which on Santander's construction we say is rendered materially redundant, and I'll come to that. And clause 12.2 refers to duties under this agreement, and that is simply referring to the duties which are governed by the agency agreement and to which it applies, to use the wording of clause 1.2. And when one looks at clause 1.2, it is clear that unless otherwise stated, the agency agreement applies to and governs the marketing and sale of both historic policies, so those marketed and sold before the effective date, and also new policies, those marketed and sold post-effective date. And it applies to and governs the parties' rights and obligations in respect thereof, which naturally would include an indemnity in respect of such marketing and sale. And furthermore, clause 12.2 does not otherwise state, and so it follows that the concluding words of 12.2 are intended to provide an indemnity in respect of both the future and the historic marketing of marketing and sale of policies within the scope of the agreement. Now, having briefly summarised the case, can we start by looking at clauses 1.1 and 1.2? And can I just hand up a sheet which breaks the clauses down? I provided, which just breaks the clause down, just in case the court finds it of any assistance. If not, it can go straight into the bin. Thanks very much. Now, so starting with clause 1.1, this expressly records in the first sentence, it expressly records in the first sentence the historic, so the pre-agency agreement, marketing and sale of the insurance as defined, and that the parties now wish to record the terms and conditions on which GECB shall continue so to act. And that then takes us just to clause 4.1, where the insurers, you will note, the insurers don't hereby appoint the agent, GECB, but they rather confirm the appointment. And it's not simply in relation to new policies as defined, but it's in relation to the insurance as defined. So the pre-existing appointment is continuing. If we then go to the definition of insurance at 2.2d, so this covers insurance products and services from time to time. So it's not limited to new policies per clause 2.2e, which are those post the effective date, but it also covers historic policies, i.e. those in 2.2a, which are expired risks, and those in 2.2c, which are existing on-risk policies. Now, an existing on-risk policy is a policy which, where there is a risk of a claim under the policy. So we see that from the words in accordance with the terms of such policy. So it's not applying to a mis-selling claim, it's applying to a policy claim. We then look at expired risks. Now, this isn't a happy definition because an expired risk can't be an existing on-risk policy or a new policy because those are policies where there's a risk of a policy claim. So what it presumably means is a policy which has been an existing on-risk policy or new policy. So it's a policy which was once active but is now expired, and so it doesn't require ongoing administration. And that's why it's not included within the second limb of 1.2, because these expired risks, while they're brought within the scope of the policy, the agency agreement, they don't require anything in relation to ongoing administration.
Although the expression expired risk is defined, does it appear anywhere else?
It does. It appears in clause 9.1a and 9.1b. And this perhaps picks up on a point which my learned friend was making before about there being two regimes in relation to ongoing administration, one before and one after the effective date. So if, for example, you go to clause 9.1a, you see over the page that what they're doing is there's this ongoing reporting going on between the parties, and they take into account expired risks when calculating the ongoing profit share. So it's not a twofold, a two-tier regime in relation to administration, one applying to the past and one applying to the future. It's simply an ongoing regime which the parties are applying in clauses 8 and 9. So although the expired risk doesn't itself generate any future premium or policy claim, the sums paid in relation to those expired risks are taken into account when doing the profit share calculation, so they remain relevant for that purpose. Now, so just going back to clause 1.1, what it is doing is it's expressly recording the fact that prior to the date of the agreement, GCB had acted as the insurer's agent in respect to the marketing and sale of the insurance as defined, and that they wished to record the terms and conditions on which that marketing and selling agency relationship would continue. Now, in recording the terms of the continuing relationship, the parties needed to address how they were going to deal with the vast number of policies, particularly PPI policies, that had been marketed and sold prior to the effective date of this new written agreement. So was the new agreement only going to apply to policies which were marketed and sold after the effective date, new policies, or was it also going to apply to policies marketed and sold before the effective date, i.e. historic policies? And the purpose of clauses 1.1 and 1.2 was to make clear that the parties were adopting the latter approach. So they were bringing within the scope of the agency agreement, for at least some purposes, and this is where the big dispute arises, was it all or was it some? They were bringing within the scope of the agency agreement, for some purposes, the historic policies that had been written over the previous decades, unless otherwise stated.
How do you get that out of clause 1.1?
Well,
You're reading it as though it said the parties wish to record the terms and conditions applicable to the agency.
I'm saying what I said.
The clause says shall continue.
Yes, that's very fair. But I started my sentence saying the purpose of clauses 1.1 and 1.2.
Yes,
It's when
I was asking you at the moment about 1.1.
Fair point. You don't get that from 1.1. But when you look at 1.2, that's precisely what you do get. You get the fact that they're creating this regime where all of these historic policies
I
get
see
brought
what you
in.
say about 1.2.
Now, there was no evidence at trial as to the precise number of historic policies that were coming within the scope of the written agency agreement as at the 1st of December. But one gets a sense of volume from the evidence of the statistical experts that the parties used when constructing the sample claims. And can I ask you just very briefly to turn to Santander's second skeleton argument, which you find in the supplementary bundle, sorry, in the original bundle at tab 5, and it's on page 76. And what you see in paragraphs 39 and in particular footnote 30 is you see a reference in footnote 30 to 12.5 million store card PPI policies pre-2005. So that's obviously to the end of 2004. Now, given that this is 4 years after the date of the agency agreement, there would obviously have been less than 12.5 million policies as at the 1st of December 2000. But it was you get a sense that it was clearly a vast number and likely in the millions. So what the parties were doing was they were bringing within the scope of the agency agreement this vast number of historic policies. And as the judge found in paragraph 271 of the judgment, based on the evidence of both parties, the intention was business as usual, and that's the phrase she uses. So the agency agreement wasn't designed to lead to new operational practices on the ground. Now, on the contrary, the way the parties had operated the business relationship wasn't going to change, but it was going to continue, as we see from the wording in clause 1.1. And can I also just refer you to paragraph 272 of the judgment at core bundle tab 9, page 164, where the judge finds that just the first sentence, the background and genesis of the agency agreement was to achieve a formalisation of arrangements which were already being operated. And if you also just look for completeness at paragraph 285 as well, sorry, 258, I do apologise.
258.
258, where she says in the second sentence, none of the evidence suggested that it was intended to affect any material change in the pre-existing relationship. As such, it contained regimes for dealing with, etc., etc. And so there was no evidence before the judge there were any material changes to the parties' operational practices, so it was business as usual. So when the judge referred in paragraph 261 to the aim of the agreement being to affect continuity rather than to bring about any bright line change, that was the point she was making. It was continuity in their operational arrangements in respect of the marketing and sale and administration of the insurance. That's what was happening. Now, in the judgment, in particular, in the section headed the relationship between Fickle and Fackle and GCB in practice, which starts tab 9, page 109, the judge made various findings as to the parties' operational arrangements. So those arrangements, those practices, which had applied to their historic dealings and which were to continue in relation to new policies post-effective date. And can I just identify a few paragraphs in the judgment, which is then going to lead us into the addenda, which, as we'll come to, are important. And the reason I'm taking the court to this is because it's important for the purpose of understanding what the parties were doing when they were recording the terms of the agency agreement, including in relation to clause 6, which has obviously now become such a central part of Santander's case, which it wasn't below, and I'm going to deal with that in due course. So can you just go to the judgment at paragraph 53? And is it better for me to leave the court to read paragraph 53?
Yes, I think so. You don't need to read it aloud. You want us to read the whole paragraph?
Just, if you could.
Yes.
So the PPI products had been designed by GCB, and that would obviously continue. And then if you look at paragraph 54, and perhaps just the first sentence of paragraph 55, if I could just ask the court to read those. And then paragraph 58, 8 lines down, towards the end of a sentence, it says only GCB had access to the retailers and the customers. If I could just ask the court to read that to the bottom of 58. So the position is that GCB designed the PPI products, it priced the products, and then it determined the premium split and the profit share. And that was obviously going to continue. And if you then go back to paragraphs 50 and 51, what the judge does here is she deals with the breakdown of the premium throughout the relationship. So both pre and post 1st of December 2000. Now, I don't invite the court to read that at this stage. But importantly, the premium splits and the profit share on the multitude of historic policies which were being brought within the scope of the agency agreement didn't change when the parties entered into the agency agreement. That they were set out in the addenda to the agency agreement. They'd previously been agreed when the existing schemes set out in those addenda had been set up, and they were going to continue to apply both to historic policies and to any new policies written under those schemes. So if a historic policy generated further premium income because after the 1st of December 2000 the customer continued to use the store card to which the PPI was attached, then the same agreed rates and the same premium split would apply as applied prior to 1st of December 2000. Now, there were 38 addenda when the contract was signed on the 1st of December 2000, and they identified all of the schemes pursuant to which insurance as defined had ever been marketed and sold by the parties to the agency agreement and their predecessors. And as the judge found in paragraph 281, and my learned friend took you to that, these included schemes that by the effective date were wholly inactive. So no new policies were to be sold under them, and they couldn't generate future income. So they didn't require ongoing administration, but they were nevertheless included within the scope of the agency agreement. So they don't apply to clause to the second limb dealing with ongoing administration and are relevant simply for the first limb, but we'll come to that in a moment. But can I take you to the addenda to the agency agreement, just to one sample addendum, number 2, in the supplemental bundle at page 29. Now, if you just look first of all, now I should just say, just to clarify.
Sorry, I haven't quite followed your point about
Yes.
paragraph 281. What the judge is saying here is that the only schemes that were discontinued were those under which no policies had ever been sold. Schemes under which policies had been sold which could be reactivated were regarded as existing schemes, Thus, Appendix 4 included several schemes under which no premium had been collected. Oh, I see, and
under which no policies could have been sold.
Yeah.
So they were entirely inactive schemes.
Yes, I see the point.
And so it's the policies being reactivated. But nothing new can be sold under these.
Yeah. Right, sorry, I interrupted you. Where did you want to
No,
go?
no, that's very helpful, my lord. Just looking at the addenda, just to clarify, the addenda include non-store card PPI policy products. So PPI attached, for example, to personal loans. For example, addendum number 1 is that. And they also include personal accident products. So, for example, addenda 34 to 38. But a majority of them are in relation to PPI store card products. And addendum number 2 is the first of the addenda that relates to a PPI store card product. And you'll see clause 2, the terms of the agency agreement apply to this addendum. The parties agree to market and sell the insurance scheme described below. So you see that these clauses draw no distinction between historic policies and those which are going to be written after the effective date, new policies. And you see that all of the terms of the agency agreement are expressly stated to apply to the insurance pursuant to these schemes, which on the face of it includes clauses 6 and 7. And if you then go to clause 4, where we've got scheme details, so we see the launch date of this is various dates, so we don't know the exact dates. And so you see under commission, so this is the premium for the purpose of clause 8, and you see that the initial commission, 52.5%, goes to GCB. That's under clause 8.1a. You then see that the retention of 5.38%, now that goes to Fickle and Fackle. And then you've got claims fund, 37.88. Now that goes to GCB, because if there is a policy claim, it's used to pay GCB as the credit lender whose loan is being paid off. Alternatively, it goes to GCB via the profit share provision, which you then have in clause 4.2. And there you see profit share 100%. And so it's always 100% of the profit goes to GCB. And you see all schemes grouped together. So all of the schemes listed in this addenda would be grouped together for the purpose of determining the profit share under clause 9. And then at 4.3, you see premium rate 78p per £100 of outstanding balance. That's the outstanding balance under the store card. And then you see frequency of premium monthly and so on. And method, you see method of reporting, bulk reporting. And so other than the retention and the tax, which are together less than 10%, the totality of the monies paid by a PPI policyholder went to GECB. And that's applied before the agreement, before 1st of December 2000, and it continues after. And if we can then go to paragraph 49 of the judgment, and if I can effectively summarise this, what the judge is making clear is that GECB controlled all aspects of the marketing and sales process, from which Fickle and Fackle were indeed excluded. And if we then go, sorry, my lord, shall I leave you to?
No, that's fine.
If we then go to paragraph 87, and what the judge says here is the emergence of PPI mis-selling as a serious issue has been described above. And she dealt with that in paragraphs 76 and 77. We don't need to turn them up, but it's there for your note. Prior to 2012, Fickle and Fackle had minimal, if any, involvement in mis-selling complaints, as these tended to be directed to GECB, with whom the customer had the credit relationship, who handled them in accordance with the FLA code to which it was subject and paid redress where considered appropriate. The only complaints that Fickle and Fackle received and processed directly were those relating to claims from the customers under the policy itself. For example, where a claim had been declined or the quantum of the claim was claim payment was disputed. However, some mis-selling complaints could reach Fickle and Fackle where the complaint was declined by GCB and was then referred to by the customer to the FOS, who in turn referred it to Fickle and Fackle. Now, that has to be after 2001, because FOS only starts operating in 2001. So what you have here is the factual position, as at the 1st of December 2000, is that GECB in practice had near total control of the design, the pricing, the marketing and sale of the PPI products. They received 95% of the premium, and no doubt in recognition of that, where there was a mis-selling complaint, GECB picked up the tab, as indeed it continued to do until 2014. So that's obviously important when one comes to consider the commerciality of the indemnity and Santander's arguments that it only applies after 1st of December 2000. Now, in terms of the continuity, as at the 1st of December 2000, of the parties' existing arrangements in respect of the marketing and sales process, can I just take the court to a few paragraphs? Could you go to paragraph 189 in the judgment? And what the judge says is it's abundantly clear that GECB knew all about the ABI code and what it entailed. See paragraphs 147, 154, 161 above, and also the evidence of Miss Greenaway. The GECB was aware at all times of the need to comply with the ABI code. Moreover, Fickle and Fackle knew that GECB had this knowledge, not least because they repeatedly drew it to GECB's attention and because the agency agreement included an express obligation on the part of GECB to comply with the ABI code. Now, can we just go back to 3 paragraphs that she refers to? Paragraph 147. And what she says is, so she's dealing with the parties' relationship. It starts on the previous page. The heading is, was PPI sold by GCB in breach of the ABI code? And so she's dealing with the evidence as there was, which starts in 1996. And then in paragraph 147, she says, in September 97, Fickle and Fackle actively promoted to GCB an ABI initiative to provide laminated cards to retail staff at the point of sale, which contained a guide to policy conditions and exclusions. We don't need to go beyond that. If you could then go to paragraph 154 that she also refers to, which is on page 141. Meanwhile, on the 9th of January 98, the FLA had produced an agreed form of welcome letter to accompany every certificate sent to an insured customer following the conclusion of a sale. And then if we go to 164, she's dealing with a meeting in December 98 at which Fickle and Fackle spelled out to GECB that it was Fickle and Fackle's agent to sell PPI and that the retailers were its sub-agents. Accordingly, GECB had to sign and return a guarantee that they and their sub-agents were ABI compliant. Now, as regards the ABI code, could you just go back to paragraph 63? And in paragraph 63, it says, as members of the BIA, Fickle and Fackle automatically became members of the ABI, into which the BIA was merged in 1985. So this is the position from 1985. But we see in paragraph 62 that the BIA code goes back to 1981. She then says in 63, in January 89, the ABI issued its code of practice for intermediaries, the ABI code, in materially identical terms to the prior BIA code. And you see then in paragraph 64 1996, there's a statement of practice regarding PPI in particular. And paragraph 64 to 66, she deals with what the codes require. But then could you go to paragraph 132? And this is under a section dealing with the applicable standards. And she heard evidence from two experts about what the ABI code required of somebody selling PPI. And this is her summary of what the experts in effect agreed. And so, for example, you'll see at little f, it required them, refer to the existence of exclusions and restrictions in relation to matters such as age, employment status, and so on, as set out in the summary of cover. And then at G, give the cover an opportunity to read the summary before entering into the contract, so they had a reasonable understanding of what they were buying before they signed. Now, so what these paragraphs make clear is that for a number of years prior to the 1st of December 2000, the parties had understood and appreciated that the marketing and sale of the insurance had to be conducted as per the ABI code, and that this involved, for example, providing the customer with certain information and material. Now, the agency agreement, as signed on the 1st of December, contained various provisions about how the agent, GECB, would conduct the marketing and sales process, what it would do, what it wouldn't do, namely clauses 5.1 and 6. Now, when the parties recorded in writing their continuing agency relationship on the 1st of December, they were not, in clause 5.1 and 6, agreeing a series of new standards that they were imposing with retrospective effect on sales going back to the 1970s. What they were doing was they were memorialising a long-standing relationship which had involved the marketing and sale of insurance policies and would continue to do so without any material changes in their operational practices, as the judge found, i.e. business as usual. So for years, they'd been operating on the basis that they were required to sell as per the ABI code, and by the agency agreement, they'd continue to operate on that same basis after the 1st of December 2000. And they'd been operating for years on the basis that this required them to provide customers with, for example, a summary of cover, and they'd continue to operate on that basis. So when they signed the agency agreement, they did not regard themselves as projecting back in time new obligations. They were writing down, they were recording, to use the word in clause 1.2, or memorialising, how they had long worked together and would continue to do so. And so similarly, the treatment of future premium generated from policies, whether historic or new, would be in accordance with the splits set out in the existing addenda, and the reporting practices, the bulk reporting, would continue as before. And the addenda, as we've seen, are policy date blinds. They draw no distinction between historic and future policies. And that then brings us to clause 1.2, where the parties agreed that after the effective date, the agency agreement would be the reference point to identify their rights and obligations in respect of past and future marketing and selling, and the ongoing administration of all policies, past and future. So they were agreeing a single regime for all past and future insurance as defined. And of course, that's the context in which the judge says in paragraph 276 of her judgment, the duties set out in the agreement were duties which were contractually agreed to be applicable to the entirety of that relationship. So can we come to the wording of clause 1.2, which is broken down on the sheet I've handed up. Now, it is a bespoke provision containing various defined terms, and it is deliberately placed by the parties at the start of the document for the purpose of identifying how the clauses that follow are to be read. So it's not a recital, and indeed, as we see from the handout, we've got two references to the parties agreeing. So the parties agree, it explicitly states the parties agree that ... this agreement shall apply to and govern. So it's an essential part of the contractual agreement, and it embodies the parties' express agreement as to the purpose and scope of the clauses that follow, including, for example, clause 17. So you don't use clause 17 to cut down the scope of clause 1.2, nor indeed does one use any clause to cut down its scope. On the contrary, the clauses that follow must be read in the light of the agreement embodied in clause 1.2. So if any clause has to give, it's not clause 1.2. Now, the opening words, unless otherwise stated, make clear that there may be provisions in the agency agreement which do cut down the scope of what otherwise the agreement shall apply to and govern. If we can then focus on the words notwithstanding clause 3.
What criterion do you apply in order to decide whether something otherwise stated does cut down clause 1.2?
Well, it can only be a process of construction of the particular provision. And so you have to read the two provisions together. But yes, absolutely, it's construction of the particular provision. Now, so just focusing on the words notwithstanding clause 3, clause 3 provides that the agreement shall commence on the date hereof, which date appears at the top of page 1, and that date is defined as the effective date. Now, the words shall commence, particularly when combined with a whole agreement clause, would normally be read to mean that the agreement doesn't impact on the parties' relationship prior to its commencement date. But the words notwithstanding clause 3 make clear that in this agreement, because of the pre-existing agency relationship referred to in clause 1.1, that is not the case unless otherwise stated. So what the words do is they make clear that this is not an agreement that is only concerned with the parties' conduct after the commencement date. On the contrary, prior conduct is within its scope unless otherwise stated. And the big issue is to what prior conduct does it apply. Now, can we then come to the three limbs of what this agreement shall apply to and govern? And if we just start with the third limb, the parties' respective rights and obligations in respect thereof. So that is a reference to limbs 1 and 2. And Santander's skeleton at paragraph 43 in the last line accepts that, although obviously it makes the point that limbs 1 and 2 are prospective, not otherwise. So limb 3 makes clear that the agency agreement governs the parties' rights and obligations in respect of both of the activities covered by limbs 1 and limbs 2. And one can ask the question, does limb 3 add anything? Well, arguably, yes, it does, because take an indemnity, it might not be a natural reading of limb 1 to regard an indemnity as part of the marketing and sale of the insurance, but it's plainly a right and obligation in respect thereof. So that's where it arguably adds to what is, in any event, in limbs 1 and 2. Now, coming to the first limb, the marketing and sale. Now, the issue here is whether this limb extends to policies marketed and sold prior to the effective date, as we contend, or whether it's confined to new policies, whether under existing schemes or under new schemes, as Santander contends. Now, the opening words are the marketing and sale of the insurance under all of the schemes. So the focus is marketing and sale of the insurance, and that reflects the wording of clause 1.1 in the second line, which refers to marketing and sale of the insurance, and also the heading of the agency agreement itself, which refers to the agency agreement relating to the marketing and selling of insurance. Now, the definition of insurance, as we've already discussed, makes clear that it's broader than the definition of a new policy, those post-effective date, and includes pre-effective date policies. So it includes existing on-risk policies, and it includes expired risks. And the definition of schemes expressly distinguishes between those created prior to the effective date, as set out in Schedule 4, and those to be created in the future. So these opening words provide that the agency agreement is dealing with the marketing and sale of future policies and also of historic policies. That's just before we get to the parenthesis. And we then have the parenthesis, and these words make clear that the agency agreement is intended to apply to and govern the marketing and sale of all policies under all of the schemes in respect of which there were, at the time of the agency agreement, existing on-risk policies. Now, the only purpose for referring to existing on-risk policies is to make explicit the fact that the policies sold under the schemes from which those existing on-risk policies emerged are within the scope of the agency relationship, the agency agreement, in relation to their marketing and sale. Because the ongoing administration of these is dealt with in the second limb. So the only reason for referring to them in the parenthesis is to make explicit that which is otherwise evident from, but not explicitly stated in the opening words of the first limb. And that's also where the inclusion in the schedules of the inactive policies is important, given that those policies, expired risks, won't require ongoing administration. They're not going to generate future premium. They won't lead to policy claims. Their inclusion is simply for the purpose of the first limb.
I'm not quite sure what the reference to existing on-risk policies does, given your interpretation of marketing and sale of insurance under all the schemes.
It's effectively belts and braces. It's making explicit that which is not explicitly stated in the sentence prior to the parenthesis. It's making absolutely clear that where there is an existing on-risk policy, that is within the scope of this first limb. That is within the scope of the marketing and sale of that policy is within the first limb.
Well, one might naturally expect that to mean that expired risk policies are not included because they're not mentioned.
Well, they are not mentioned, but they are within insurance under all of the schemes.
Well,
So they are in there anyway.
In that case, my question stands: what does the parenthesis do on
Well,
your interpretation?
It may be that it adds nothing to what is already there, but it simply clarifies that in relation to all of the existing on-risk policies that are existing and on risk as at the 1st of December 2000, they are being brought within the scope of the agreement, or being brought within the scope of the first limb of the agreement. So their marketing and sale is relevant. They are within that. And so the third limb then makes clear that the agency agreement applies to and governs the parties' rights and obligations in relation to the marketing and sale of the policies under the schemes in the addenda. And an indemnity against liabilities arising from the marketing and sale of these historic policies would plainly be such an obligation. And indeed, in the context of the agency relationship, what could be the legal relevance of the marketing and sale of these historic policies, if not the liabilities that would arise from them? That was the purpose for bringing them in. What other provision in this agency agreement, if not clause 12.2, has relevance to the marketing and sale of these historic policies? Santander hasn't identified any other provisions. So clause 1.2 clearly intended clause 12.2 to be within its scope unless otherwise stated. Now, can I pick up Santander's response to this construction And we've obviously heard my learned friend's arguments this morning, but a good starting point for dealing with it is his skeleton argument in tab 2 at page 25. And we've got the section, the judge's erroneous reliance on and misconstruction of clauses 1.1 and 1.2. And in paragraph 39, in the last sentence, it asserts that if anything, those clauses, so this is 1.1 and 1.2, reinforce the conclusion that 12.2 only applies prospectively. And then the analysis for that assertion is what follows. Paragraph 40 is an assertion that those clauses have no relevance when construing 12.2. Paragraph 41 dismisses clause 1.1 as in effect a recital which sheds no light on the scope of the agency agreement. But of course, 1.1 and 1.2 have to be read together in order to understand what the two clauses are communicating about the scope of the agency agreement. We then go over to paragraph 42, and the first sentence makes the point that clause 1.2, like clause 1.1, does not address the position on indemnities. That's true, but so what? It's a provision which deals with the scope of the agency agreement without expressly dealing with any specific provision, including in relation to ongoing administration. But if you then go to the second sentence, we get to the meat of the argument. So the first limb apparently addresses a lack of clarity that might otherwise arise. And paragraph 43 then explains the apparent lack of clarity. And this is the point that my learned friend was making today. The natural meaning of the provision just quoted is that point 1, so that's the first limb, is concerned with the prospective marketing and sale of the insurance referred to. The second limb is concerned with the prospective administration of the insurance referred to. And the third limb is concerned with the rights and obligations arising from these prospective matters. Now, just 2 points on that. Firstly, this supposed natural meaning of the first limb simply flies in the face of the express words. That there is no attempt to deal with the words in parenthesis and the express reference to existing on-risk policies or to the broad definition of insurance. And if, as my learned friend asserts, the intention had been to clarify that the agency agreement only applied to the marketing and sale of new policies, why refer to the marketing and sale of policies under all of the schemes in which there are existing on-risk policies and make no reference to new policies at all? I mean, clearly, one doesn't construe the first limb as prospective. That is just a total misreading of the wording. And the second point is, there is no lack of clarity which might otherwise arise, because the effect of clause 3 and clause 4.1 is that the marketing and sale of any insurance after the effective date is expressly within the scope of the agency agreement. And that would obviously include marketing and sale of new policies under existing schemes, as well as new policies under new schemes. So there was simply no lack of clarity whatsoever. Now, can I then just, in fairness to the judge, deal with the criticism that is made in paragraph 46, where it said that she didn't address the arguments in paragraph 42 and 43, despite appearing in Santander's written opening and closing. Now, that is an unfair criticism. Can I just ask you to go to the judgment at paragraphs 264 to 267? Now, what happened? What happened in oral closings was that Mr. Zellick advanced a new construction argument, different to that in Santander's written opening and closings, and we see that from paragraph 264. We see how in their written closings they addressed the point, and the new argument was that if I don't know whether it's helpful to have the sheet I handed up, but the new argument was that the second limb of clause 1.2 was the ongoing administration of all existing on-risk policies. So it stops there. And there was then a third limb, being new policies entered into between insured customers and the insurers pursuant to such schemes. But nevertheless, his construction of the first limb remained unchanged, and you see that in paragraph 265A. It's the same as what you see in 264A. And as the judge rightly found in paragraph 267 in the last sentence, this new construction appeared to make the first limb on his construction of the first limb redundant. But the critical point is that the construction being advanced in respect of clause 1.2 was that it didn't apply to the marketing and sale of historic policies, which has always been and remains Santander's argument. And the judge disagreed with that. And she concluded, we say rightly, that clause 1.2 in the first limb did cover the marketing and sale of historic policies. Can I just say something very briefly about the phrase unless otherwise stated? Here the parties are making explicit the fact that the agency agreement will have the scope set out in 1.2 unless a particular provision expressly states otherwise. And as I said a few moments ago in answer to my Lord's question, it's obviously a question of construction as to whether or not a particular provision does in fact expressly state otherwise.
On your submission, does any provision state otherwise?
Yes, if you would like an example, clause 9.1.
Sorry, clause?
Clause 9.1. Where you see 9.1, the insurer shall, subject to GCB complying with its obligations under clause 9.5 within 20 working days after the effective date, calculate. So it makes it absolutely clear that this applies after the effective date. So that is an express contrary statement in relation to that. Now, can I then come to clause 12.2? And there are two preliminary points to make about clause 12.2. First, unlike clause 1.2, it is likely a boilerplate provision taken from another agency agreement. And you will note that it refers twice to the insurer rather than to the insurers as they are defined elsewhere and indeed on page 1 of the agreement. So it is likely you were taken to the judge's reference to the expert evidence about agency agreements invariably containing indemnity provisions of this nature. So the likelihood is that it was a boilerplate provision taken from one of these frequently used agency agreements. So that's the first point. The second point is the likely reality of what has happened with clause 12.2 is that since it was probably a boilerplate clause, it was presumably drafted or designed for a contract where the agency relationship started on the same day that the agreement started, i.e. day 1. So it wasn't written with a view to a contract involving a decades-old relationship which was being continued and recorded in writing. And so in those circumstances, the concluding words of clause 12.2 hadn't been drafted with any regard to pre-day 1 activities, whether to include them or exclude them, but simply sought to make clear that the indemnity was limited to the agent's activities pursuant to the agreement. But what's happened is that in our case, the words are being applied to a relationship where the agent's activities had been performed for decades before day 1. And in our case, clause 1.2 makes clear that those activities are included within the scope of the agency agreement unless otherwise stated. So coming then to the construction of clause 12.2, it can't be read in isolation. And in our submission, it's to be read in a way that is consistent with the parties' express scope setting agreement in 1.2. So unless the parties have otherwise stated in 12.2, the indemnity is a right and obligation in respect of the marketing and sale of both future and historic policies. Now, it's common ground that the indemnity is a right and obligation in respect of the marketing and sale of future policies, so the dispute is obviously whether it extends to the marketing and sale of historic. Now, focusing on the 7 last words, the concluding words, what do they mean? Now, Santander's contention is that it's clear and unambiguous from these words that they are imposing a temporal restriction on the scope of the indemnity because GECB could only perform duties under the agreement after the effective date, and therefore it's restricted to acts or omissions after the effective date. Now, one obvious answer to that is that the concluding words are not at least explicitly words of temporal restriction. And given that the agency agreement contained bespoke contractual definitions which could have been but weren't used to address any temporal issue, so words like effective date and new policies, it is surprising that the parties chose not to use those words if they explicitly intended to restrict the scope of the indemnity in this way. And you've seen clause 9.1, where they wanted to refer to the effective date, they referred to the effective date.
I'm sorry, we're getting into a bit of a tangle here, aren't we? On the one hand, you say this is a boilerplate clause, and the drafter of the clause intended it to apply to an agency relationship starting on day 1, so it has prospective effect only. And yet you say it's surprising that the parties didn't put in some temporal effect to change the boilerplate clause.
No, the point I'm making, my lord, is if they had intended, when they slotted this clause into the contract, to restrict the scope of the indemnity in some way, if they'd intended it to have any temporal restriction.
But the premise underlying your boilerplate clause point is that the drafter of the clause did intend it to have that effect.
Oh, the drafter of the original template clause might have done, but the parties simply slotted it into this agreement without expressly addressing their minds.
Yeah. Is there actually any evidence about that? I mean, you make that assertion, but do we know?
No, there isn't. I mean, all there is what appears in the judgment, where the judge says one is a bespoke clause and the other is likely boilerplate. It is boilerplate, and then refers to the evidence of the experts. So that's as far as I can go. But in any case, I mean, the point that I'm making is that if there had been an explicit objective intention to contain a restriction in clause 12.2, it is very surprising that the parties, if they had addressed their minds to it, didn't use any of the definitions that they explicitly created for the purpose of this agreement, including 1.2. But the other key point to note is that Santander's construction means that the first limb of clause 1.2 is in effect emasculated. If clause 12.2 doesn't respond to liabilities generated from the marketing and sale of historic policies, the first limb of clause 1.2 is completely redundant as regards the marketing and sale of those historic policies. On Santander's construction, there is no provision in the agency agreement relating to the marketing and sale of historic policies. Now, given that clause 1.2 is the scope-setting provision in the agreement, that's a pretty implausible result, absent clear wording in clause 12.2. And we say the 7 last words are not clear words of contrary intent. Now, it is also important to bear in mind that the reference to duties in clause 12.2 is not a reference to clause 6 in particular. And of course, one gleans nothing from the use of the word duties in the heading of clause 6, because clause 2.3 makes it clear that headings are for information only and shall be ignored in construing. But more substantively, the concluding words of 12.2 make no express reference to clause 6. And indeed, there are many duties imposed on GECB under the agency agreement other than clause 6 duties. So there is no reason why clause 12.2 must be referring to clause 6 in particular. And importantly, it is common ground that the indemnity doesn't require Fickle and Fackle to establish a breach of clause 6, or indeed of any clause. It indemnifies Fickle and Fackle for liabilities arising from acts or omissions by GECB, including negligence. So it's not just express contractual duties. And so we do say that for these reasons, it would be very surprising if clause 6, rather than clause 1.2, determines the temporal scope of clause 12.2.
Not following this, there's symmetry, isn't there, if you look at 12.2, and the same argument seems to apply to 12.1, between the opening words, compliance with the insurer's duties, and the closing words, whilst performing their duties under the agreement. On what basis can the reader of this clause pick and choose between some duties in the agreement,
You can't.
unspecified, as opposed to all duties in the agreement, including clause 6?
My Lord, I'm going to pick up on exactly that. Can I first of all just make this point? It was no part of Santander's case at trial that the construction of clause 6 informed the construction of clause 12.2. And
Maybe.
no, but I need to lay the groundwork, and I'm going to come to that because I want to show you how they presented it at trial.
Why does it matter?
Well, it matters because of the point that I was making before, that what the parties were doing when they recorded, when they set out the provisions in clauses 5.1, 6 and 7, what they were doing was they were memorialising provisions.
Well, I've got that point, but
Yes.
why does it matter how they argued it at trial? We've
Well-
got to decide what the contract means.
But because it deals with the point that I've just been asked. But can I just take it in stages? So if you just go to their closing submissions in the supplemental bundle at tab 11, and if you just go to page 443, and in paragraphs 112 to 123 is where they deal with the indemnity. And so they say it's not retrospective. But what you will note, if you just flick through it, is there's no reference to clause 6. So it was no part of Santander's case at trial that in terms of construing clause 12.2, you've got to look at clause 6. Clause 6 was an irrelevance. And one of the reasons to take the court to this is that in paragraph 38 of my learned friend's skeleton, the judge is criticised for not dealing with, among others, clause 6. Well, she didn't deal with clause 6 because it wasn't any part of their case that it was relevant to the construction of clause 12.2. But if you just look at paragraph 115 of Santander's closing submissions at trial, what you see is there is a reference, a few lines from the end, to the insurer's duties under this agreement can only be a reference to Fickle and Fackle's duties under the agency agreement as executed on 1st of December 2000, such as clauses 5.1 and 7. Before 1st of December 2000, this agreement and Fickle and Fackle's duties under it did not exist. Now, however, the logic, and crucially, the logic of
Next sentence.
the expression under this agreement must bear the same meaning each time. Yes, can I just now take you to their closing submissions at 453 to 454? So this is in the section, if you just go back, this is in the section, Fickle and Fackle didn't comply with the conditions precedent to claiming an indemnity. So they were dealing with the opening words that my lord...
Which paragraph again, please? I'm sorry.
It starts 453, section 5, Fickle and Fackle didn't comply with the conditions precedent. So this is the opening words. And what you see is, take for example 137, Fickle and Fackle's relevant duties were set out in clauses 5 and 7 of the agency agreement. The defendant's position is that if and to the extent that GECB was in breach of selling standards or guilty of mis-selling, as the claimants now allege, this can only be directly attributable to and caused by Fickle and Fackle's failure to comply with their duties, in particular under 5.1, 7.1a, b, d, and f. So the logic of Santander's arguments at trial was that clause 7 was indeed retrospective. It applied throughout the course of the relationship. So when they were arguing that Fickle and Fackle had failed to comply with the opening words of 12.2, including in respect of historic policies, sold before the effective date, which were the mass majority, Santander's position was that the relevant duties were those in clause 5.1 and 7. So in Santander's phraseology, they were retrospective. And if you then go to the judgment, paragraph 308, where the judge is dealing with this issue of non-compliance, she says, as ultimately articulated in closing, Santander's case was that Fickle and Fackle were in breach of clauses 5.1 and or 7D and F, so on. And so what this reflects is, and of course, there's no appeal from this. And what this reflects is the point I was making earlier. When the parties recorded their agency relationship, they were not, in clauses 5.1 and 6 and 7, agreeing new standards, which they were imposing with retrospective effect, going back to sales in the 70s. They were memorialising and recording the provisions of a long-standing agency relationship, which had previously applied and would continue to do so. So 5.1, 6 and 7 simply recorded the duties owed by the parties to one another throughout the duration of the relationship. And that's the case they ran.
Right.
And
shall we leave it there and come back at 2
yes.
o'clock?
For
2
I
o'clock.
is able.